so.
Ms. Maggie?
Meiji.
Thank you, I'm sorry, my bad. I'm putting together some handouts.
Oh, wonderful, thank you. Yes, okay.
I'm David Bloom from All Students in Court.
Oh, yes.
Justin Kingsolver.
Justin Kingsolver, Judge
Helen
Howard
Gertie.
Gertie.
Nice to meet you.
Okay.
Thank you.
Okay.
I'm Dan Clark.
Yeah.
Okay.
Ladies and gentlemen, unfortunately, due to a personal matter, we have a last minute. I shudder to use the word substitution because they're really two great, different, wonderful people. But Dan Clark will not be joining us today. However, his colleague, someone who I've also worked with, David Blum, who has been a staff attorney, senior staff attorney in the Civil Division of DC Law Students in Court. Has it been 4 years now?
This is my third year.
Third year, okay. And you're an alumnus of the program too.
I am, yeah. I've never left.
Okay. Yes. So given that lunch ended a little late, and I think some people still haven't gotten their dessert yet, I'm going to allow a few more minutes for people to come in.
There was dessert?
Yeah.
Do you want me to write my name?
Sure.
Okay.
Yeah. All right.
I don't see evaluation forms.
They should be. There should be an envelope. Oh, here it is.
I'll get it.
Okay. Thank you.
I'm gonna,
So,
some handouts.
just to let you know, I envision this to be an informal conversation. There should be plenty of time for questions. I do want to say, though, this is not intended to be a how-to about how to litigate. So if you are interested in learning about that process, the Renter's 101 course going on might be more suited for that. I'm just saying. We are going to talk about a lot of different things, but it's not going to be. Now, a little disclaimer, when it comes to questions, obviously I'll let Judge Curry be the judge of what she considers appropriate or not, but in general, it is very inappropriate to ask a judge who either is hearing a case that you might have before her currently or in the future to ask her opinion about how a case may turn out or what her advice is about X, Y, Z. So if we can avoid an awkward situation from even developing. Do you have anything to add to that?
Yeah, I am prohibited by law from giving legal advice.
Okay.
So you can talk to me about a case, but I can't give you any advice. I can tell you what the procedural rules are,
Yes.
especially the procedural rules as they relate to the Office of Administrative Hearings, but I really can't talk to you about a case. And if there is one that's going on at OAH that you know about and want to talk about, I cannot comment on it at all because I might end up hearing the case or be participating in it in some way. So
Makes sense.
But actually, as it is, unless you have a retainer agreement with one of the attorneys sitting in here, there isn't an agreement to provide legal advice. So anything that is said in here should not be construed as legal advice. You are always encouraged, if not urged, to seek independent legal counsel for any specific issue that you might have. All right, let's see. Sir, if you'd like, there's plenty of room at the table. Okay, wonderful.
To give you one moment, I'm going to hand out an evaluation form. It's very important for us to get your feedback about the session. So make sure you fill that out and get that out collected at the end of the presentation. It's very
How do
important.
you want to spread out?
We appreciate it when you get your feedback.
maybe
All right.
job applications in.
Not since, no. My fiance is going through that process right now. He's waiting for his bar results and doing a
Okay.
job search. So that's,
So just a straw poll, no right or wrong answer here. How many of you have ever litigated or been represented in a landlord-tenant case in the district? Okay. In the Office of Administrative Hearings? Small Claims Court? Well, I guess you've gone everywhere on this. The Housing Conditions Calendar. And the Landlord and Tenant Branch. Now, unfortunately, it's just not possible to cover every possible forum, but just out of curiosity, Office of Human Rights, District of Columbia Housing Authority Fair Hearings. Okay, just wondered. All right, well, if someone could shut the door there, please. All right. So, Judge Curry, I don't mean to put you on the spot as the first question here. In general, what do you think parties appearing before a judge at the Office of Administrative Hearing can best do to best put on their case? Like, what are things that you see frequently that indicate to you the parties are very prepared, they're respectful of our time, they understand how we operate here, and go forward there?
I think that the very first thing that a tenant should do, or a housing provider, when they're appearing in front of the Office of Administrative Hearings, is make sure that they read the case management order very carefully, because that outlines how to present documents in advance, which everybody requires you to do. So be prepared to read through that. If you have any questions, we have a resource center that helps. And when presenting your case, it really helps to walk through things logically, to talk about one issue at a time, either chronologically or issue-centered, sort of be focused and walk through things in a logical manner. That allows us to hear the case and to understand without having to go back and take little bits from different parts of your testimony. And I think the most important thing, though, the very most important thing, is to read the case management order and to make sure that you submit in advance all of the documents that you want the court to look at in advance and during the hearing.
And thank you, Judge Curry. And frankly, I'd like to add that, in my opinion and experience, that is just a common sense point for any litigation tribunal that you might be in. If Dan Clark were here right now, he taught me specifically to always read the rules before you go before a panel. So just, you do need to do your homework in advance. I guess we could have a takeaway from that. All right, so Justin, David, from the perspective of other of your opposing counsels, whenever you're in a courtroom or in a tribunal room, what indicates to you that you have your work cut out for you, you have a formidable opponent, they know what they're doing, and let's just say no favors are going to be done for you? Any indications there?
I would say the strongest, well, actually, one thing I should say before. So I work at a law firm called Crowell & Mooring. I just would like to say that any opinions that I'm expressing here are mine alone, and they do not reflect my law firm, any lawyer at my law firm besides me, or any of my clients or the firm's clients. But to respond to the question, I think the single, so I mostly do eviction defense, and a lot of it is non-payment of rent. So in that situation, I think the single greatest indicator that I'm facing an opponent that will be a difficult opponent is when I see any kind of evidence before we enter the hearing. If I see a rental ledger before we get into the hearing, if I see some kind of evidence that the housing conditions issues that we've raised have been rectified, then I know they're serious about it. Because in my experience, so many times the opposing counsel, they're filing 20 or 30 or 40 or 80 complaints a day, which makes it very difficult to conduct an independent investigation on every single one of these claims. So when I see that, I guess, evidentiary portfolio beforehand, that can really indicate that I'm facing a stronger opponent.
Before responding to that, Justin did an excellent thing, which I think I should second too. Do not construe anything that I'm saying to be representative of my office or the DC government, for that matter. Do you have anything to add to that point, David?
Yeah, so I don't think I need to do that sort of disclaimer.
Oh, no,
But
well, that too, I meant to the
Yeah,
question about your adversary.
yeah, so I think, so I'm at landlord-tenant court at least 3 times a week, possibly 5 days a week, doing general intake and brief services. So I see pretty much every landlord's attorney, almost every plaintiff, and almost every cause of action. And I would echo what Justin said about if the landlord's attorney is actually very prepared for the case, that means that we do have our work cut out for us. With regard to type of case, I think the hardest for a tenant to defend against is a one-strike case, which is a federal law that allows tenants to be evicted for criminal activity in public housing units. It's just very difficult, and often the housing authority is very unforgiving regardless of whether the person being sued for eviction is the actual person who committed the offense, because the Supreme Court in, I think HUD versus Rucker is the case, Harrison can correct me on that, said that it's perfectly fine to evict for example, a grandma because her grandson committed a crime.
In
So,
the unit?
In the unit or on the public housing authority property. So I think those are by far the most difficult, but they also show the intersection of various courts, because if a tenant comes in with a one-strike offense, we have to closely monitor or closely examine the underlying criminal case. Because if there's a conviction or a guilty plea, it becomes way harder. And
Question, and I understand if you don't know the answer to this. If a tenant gets a one-strike notice, are they able to challenge it before the DCHA, the District of Columbia Housing Authority hearing process, or do they just have to plead their case to the landlord-tenant court judge?
it's my understanding that they cannot challenge before the DCHA pleading process.
Very well. Okay. Here's the, honestly, in a lot of ways this is improvisational. I didn't know in advance how many people were gonna be in the audience, frankly. I think we're a small enough group that, do the panelists have any objection to taking questions? Basically what might make sense, and I'm happy to hear your feedback about this, is we discuss a theme, we do questions, then we come back. So is that okay with you, all of you? All right, so sure, open the floor.
I just wondered if somebody's doing this but not on the property, are they subject to this one striking, or is it just things that happen on the property? You made it sound like it was just...
Right.
Well, that's for the one strike law. I believe, if I may, I believe that 501C of the Rental Housing Act does allow evictions on the basis of a criminal conviction. I don't have the act in front of me, but I do believe, I'm not sure if the crime needs to have been committed on the rental property.
So that's right.
Okay.
The major distinction between 501C and one strike, though, is you can issue a notice in a one strike case prior to an adjudication of the criminal case. And whereas 501C explicitly says that the case has to have been, like the underlying criminal case has to have been decided. But prior to the issuance of the notice.
Very well. Do we have any other questions on this topic? All right. So we've now talked about how we have, how we know that we have a strong adversary. Any pet peeves about what another side frequently does that you just wish they wouldn't? And Judge Curry, I guess, in general, are there just bad habits that you see litigants do frequently that you would feel comfortable saying, please don't do that, as far as what not to do, just in general, what not to do?
Well, I think the reverse of what you should do is pretty clear. If you should read the case management order, which gives you instructions about how to prepare for the case, my suggestion would be not to show up for your case expecting to be able to submit documents when you haven't submitted them in advance of court, and share them with the other party in advance, like the case management order says. That's probably the hardest thing for our office to deal with. at the time, especially if somebody comes with 100 or 150 documents that they want to submit, and they haven't shared them with the other side hasn't had an opportunity to look at them. It's sort of about fair play, letting everybody know what the facts are that you think are gonna happen, and be introduced as evidence in advance so that they can prepare to deal with them.
On that note, I'm sure that the case management order, the rules of the court, and actually I would like to point out, Mr. Williams over there is preparing some handouts. They do include a pamphlet issued by OAH called What to Expect at a Hearing. I do encourage everybody to look at that, and that may provide some insight. I'm just wondering, do you find it to be a common occurrence that people will try to go beyond what a tenant petition allows and start to argue for things that just are not within any jurisdiction that your court has?
It happens occasionally, it does, but our jurisdiction is very, very limited. And the judges are usually pretty good about saying that's not something that we have jurisdiction to decide in this case.
Because I'm thinking probably offhand the most common example that I see where people ask me about bringing a case, and the thing that I probably most often have to say OAH cannot deal with is, for example, damage to personal property.
Right. The remedies that are in the Rental Housing Act specifically address rent reductions, rent rollback, and fines. And those are the only remedies that we have the jurisdiction to award.
And do our other panelists have anything to add on that point?
Yeah, to your question about, I guess, pet peeves.
Yes.
I would say that my response to this would be the flip side of my earlier response about, you know, the most intimidating opponents being the well-prepared opponents. My biggest pet peeve is when I'm dealing with opposing counsel that is not aware of the underlying facts and makes some pretty egregious. I'll tell one short anecdote here in a second about that.
Share all the anecdotes that you wish. This is designed for all that, so don't apologize.
But in my practice, so I do not do housing law as my main practice. I'm an antitrust litigator, so this is my pro bono practice. But in that practice, I'm normally dealing with a set of, there are normally like one or two different law firms that I'm dealing with, and they're well-respected tenants or landlords attorneys. But I will ask questions or I'll raise issues, and then I'll get a response that makes it seem like the opposing counsel has done some factual investigation, like asking the landlord, is this thing true? And then they'll give me a representation that will many times turn out not to be true. Here's an example. I represented a mother of two, a pregnant mother of two, who had filed a housing conditions calendar complaint on the housing conditions calendar because she had a hole in her wall that was about my wingspan, and there was mold all around it that her landlord had fixed with a piece of cardboard. And another issue that arose during the course of the case was that the front door to her rental housing unit, so the apartment building, the front door, the lock was broken. And this was just right before Christmas. I remember because I actually dealt with this on Christmas Day. The landlord's attorney, I told him, I remember telling him the day before Thanksgiving that the lock was broken. And, you know, things were, and my client was in danger, her kids were in danger because people could just get into the house. And then someone set a fire in the laundry room of the building, which was the room right outside of her house, or right outside of her unit. So I angrily called opposing counsel on Christmas Day, and he said that his client had told him, and he was representing to me, that the lock had been fixed, and there was no way that could possibly have happened. So I called my client back, and I said, can you go just take a picture of the lock on the front door? Because your landlord is saying that he sent someone out yesterday and they fixed it. So she did, and the picture that she sent back to me Not only was the lock not broken, not only was the lock broken, or not only was it not fixed as the landlord's attorney had said, there was no lock whatsoever. There was a hole in the door where there was supposed to be a lock. And I think kind of my method of operation in this is kind of how I would handle any case. It's tell the truth and know your facts. And it really upsets me when, we, as lawyers, we all go to law school and think, we're going to litigate in a different way. We're going to be upstanding members of the legal profession. And I think it gives all of us a bad name if we don't investigate the underlying facts. Or if we bring, I would say, much shorter, my other pet peeve is when landlords' attorneys bring complaints without investigating the facts. Their landlord client says he hasn't paid his rent yet. And the landlord's attorney doesn't even ask for the ledger. Doesn't ask to see any evidence that there's not been rent paid. And then we have to go into court and we have to file a motion to dismiss, or we have to enter an appearance and go through all the motions for something that should never have happened in the first place if that landlord's attorney would have just done his homework, his or her homework.
My understanding actually is that a lot of that process is automated. There's like the landlords keep a ledger, and as soon as there's like one little missed payment, regardless of when it was or how long it's actually there, it just shoots an email over to the landlord's attorney.
As soon as the system says there's
Yes.
a missed payment, which many times does not reflect.
Right, nobody even there's very little verification, and that's why on the day of the initial hearing, you see so many bulk dismissals, because that's when they bother to actually check.
And just for the non-lawyers in the room, that is so foreign to any other court. Like if someone did that in the United States District Court for the District of Columbia, they'd get sanctions immediately. I mean, that is so unacceptable. That is not the way the practice of law is supposed to be conducted.
I actually witnessed a pro bono counsel attempt to file a motion for sanctions against a landlord's attorney for doing something like that, and asking for attorney's fees and he used like the billing, the hourly billing he would charge his regular corporate clients as the basis of the attorney's fees. And the landlord's attorney was just like, "What do you want me to do? It's all automated. I don't have anything to do with it." And the judge sided with the landlord's attorney.
Right.
Said, "This is the way the system works. This is just the way it is."
Well, honestly, to be frank, and this is again speaking only for myself, not for any of my clients or my law firm's clients, that's something I would like to do. And I've decided that will be my regular practice going forward. I've just finished dealing with another motion to dismiss where I put probably 15 hours of my time, and just so I can, so it was a claim that really involved maybe about $1,500. And I don't say this for don't read anything into this beyond just trying to provide context. My billable hour rate, if we were billing it out to a corporate client, is about $425 an hour. So if I'm spending 15 hours at $400 an hour, it would be a significant obstacle or a significant deterrent if we as pro bono attorneys made it our regular practice that if we have to file a motion to dismiss that is just on the basis of one of these kind of claims, I'm going to make it a part of my regular practice to always seek attorney's fees. And if we get denied, we'll just keep getting denied. And I think once enough pro bono attorneys do it, maybe there will be some.
I think you'll find a lot of
changes.
support for that.
I believe, and actually I meant to say this early on, I will hand out my business card, and if a case is cited or a document is mentioned that's not provided in the handouts, or if you want another copy, please do feel free to email me, and I will be happy to provide that. Oh, yes, ma'am.
This may be kind of a stupid question.
No stupid questions.
How about attorneys who show up late or they're out in the hallway when the case is called? Because I unfortunately had to go to Landlord Tenant Court a couple of times, and the attorney was out in the hall, and my legal aid lawyer would go out and get them, and I felt like, no. No, I want to ask this to be dismissed for failure to appear. I mean, I don't understand why you guys are so collegial, and I wanted somebody who was an advocate.
Okay, all right, here's the thing. I'll let my co-panelists give their own response. Here's what I need to say. I understand that can be very frustrating, but at the end of the day, the system depends on collegiality. Just because lawyers are being collegial does not mean that they don't have your best interests at heart or that they're trying that they're trying to pull punches.
But if the tenant doesn't show up, then it's.
Default.
They're out.
Mhm.
So it's really not fair to give.
But could I add a little?
Sure.
I'll be a little more aggressive on my response. So I would tend to side more with kind of your thought, like, well, if we can win that way, let's win that way. But let's play that out. So if your landlord's attorney's out in the hallway, then you go up and, the clerks all know the landlord's attorneys because they're in there all day, or they're in there every day. So you go up and you say, I would move to dismiss for failure to prosecute. And then the clerk would say, well, he's just out in the hallway, let's go get him. And the reason why I say that, like, there's no rule that I can cite to that says that they would do that, but I've seen instances during a continuance will be considered. So there will be, both sides will go up and talk about when they want to move the initial hearing. And there will be landlord's attorneys who, there will be only one day where the tenant's attorney can appear, or where the tenant, him or herself, can appear. But because the landlord attorney doesn't normally come in on Fridays, it can't be scheduled that day. And I just think that the administrative functions of landlord-tenant court are so dependent on and protective of landlords' attorneys, kind of in these structural, endemic ways. It's just really hard to combat that.
I will say this, from personal experience, I can tell you that it does go both ways. For example, if the lawyer for the landlord, if it's their turn in court and we're talking after roll call and they're going through the cases, if a tenant, for example, wants to have time to go speak with a volunteer attorney who isn't representing anybody specific, but who can answer questions, if, for example, they were to call our office and be able to speak to someone right away, or if they want to go to the Landlord-Tenant Resource Center, being polite to the landlord attorney and having collegiality allows that to work. And at the same time, but you know what, I don't think any of us can disabuse you of the frustration that you experienced there.
There are some small landlords that find lawyers out of nowhere who don't know the rules.
Do they still make phone books?
And so the one guy I know, he was from another county, so he didn't know the rules. Just out of nowhere. I would have no mercy.
Now, I'd like to ask Judge Curry, I know that in the Office of Administrative Hearings, there's usually not drawn out discovery like depositions, interrogatories, requests for production, and the back and forths that happen in general litigation. But do you notice a better dynamic when, if both sides have an attorney, and again, no one needs to say that it is often unaffordable for tenants to have an attorney. But when you see two attorneys who, even though they are formidable adversaries, but clearly do have a respectful, albeit still adversarial relationship with one another, do you believe that doesn't it help efficiency, just provide a much more agreeable atmosphere if at least there are two lawyers who don't hate each other's guts, even if the parties do?
From my experience sitting on the bench, and let me preface this by saying that I've been an administrative law judge for over 2 years now, but before that I was a magistrate in Michigan. And very frequently, in fact, the majority of the cases that I heard were people who were unrepresented. And it never helps a case when emotion is controlling how somebody acts in the courtroom or how somebody treats the other side. I understand that the parties have a lot of emotion there when they come to court, but if I have two attorneys who are respectful of each other, even if they completely disagree on the law and they completely disagree on the facts, if they're respectful of each other, it makes the proceeding go a lot more smoothly. We can actually get to the hearing and get to the collection of evidence, which is what a hearing is for. If there's a lot of nitpicking back and forth and disrespect between the two parties, then I end up having to basically play referee a lot more than doing what my primary job is, which is collecting evidence to make a decision. And it doesn't help. It makes me frustrated because I cannot get to the point where I can actually get the information I need to make the decision that will affect both of the parties.
David, we haven't heard from you on this topic.
Yeah, so I think I definitely understand how it's difficult because, you know, going back to the original question, one of my pet peeves is how poorly a lot of the Landlords Council treats the tenants and how callous they often are with the tenants. Just for an example, I have a client in Housing Conditions Court who had a fire in her unit in January. The place is still not up to code. And I have argued with her attorney to press his client to do something. And he has responded on multiple occasions like, why do you care so much? You don't have to live there. And that is the general, that is often the posturing that a lot of landlords' attorneys will take. And so I can absolutely understand how it's frustrating from a tenant's perspective, from a client's perspective, to see somebody who is treating you that poorly and then see your supposed advocate acting kind of collegial with them. Like, I make a point when I'm speaking to a client to refer to the landlord's attorney by Mr. or Miss rather than their first name, even though I'm on a first name basis with them, just to not kind of present the collegiality. But the fact is, as everybody has said here, lawyers on opposing sides do need to work together for the process to go smoothly. If the process was being opposed at every single point, at every single minor detail, that wouldn't be good for either side. And having a collegial relationship with a landlord's attorney, for example, lets you ask them to, can you please go back to your client and just ask them if they'll give them a little bit more time to pay, if they'll give them a little bit more leeway, if they'll work on a good behavior agreement, something like that. So there is a benefit, but I 100% understand how frustrating it is that these people that are treating you so poorly, your lawyer has to play nice with them.
We have a question.
I'd like to ask a question.
I see you after. Okay.
Tenant petitions,
Okay.
are they, am I to understand they come before the Office of the Administrative Hearings? Is that-
Yes.
okay. So, in reference to what this gentleman was talking about, I have a different situation, but how to determine whether or not to file a tenant petition as the tenant association president, that I am, versus an individual?
Okay, that can be extremely fact-specific depending on the issue. Now, I do believe that the law gets into when a tenant association has standing to go for an individual. There are also certain claims that can be brought by the tenant association as the entity of the tenant association. I mean, I shudder to get too fact-specific, but do you have a more specific example that you're just generally wondering
Well,
about?
the one is that the roof, we have a roof deck and a pool, and it's promoted as an amenity of the building. We recently had the entire roof deck renovated this summer, so it shut down, ended up being delayed after delay, but when it was opened up, the pool is half the size now. And then it's dangerous to walk up on the roof now, you know, because there's different type of surface, and we have some other issues.
Is the building rent controlled?
Yes.
Okay, this is what I'm gonna suggest. I will give you my business card. What you're asking about probably does require legal advice as far as filing a tenant petition, because there are pros and cons on that. So, I guess to answer your question, it might be feasible or desirable to do a tenant petition, but I'm afraid, I don't think, we really can't get into that at this forum.
Okay, thank you.
Yes, sir, in the back.
If I could
Oh,
just-
sorry,
If I
of
could
course.
just add that the rules for the Office of Administrative Hearings address the tenant association representation. And so you want to look at that as well.
Yes. There are very, as David just points out, the procedural rules, and if anyone emails me this week, I'm certainly happy to send a link to that. There are OAH procedural rules that get into who has standing when the association can represent others. So Standing is always a very important threshold question. Yes, sir, in the back.
Yes, my question is probably something that will maybe save the Office of Administrative Hearings another item on its schedule. But it relates to the marvelous Department of Consumer and Regulatory Affairs that goes around giving notices of infraction. And I recently got one with regard to grass being too long.
Sir,
in my yard.
just,
And
okay.
I just want to, it's a procedural matter. And last year, or 2 years ago, I got one for grass being too long. Took photos of it and sent it, went down to the office. Bingo, it was done. It was abated, okay? Now, this time, when I did that and went to the DCRA office, they would not accept my photos. They said, oh, you have to go to the Office of Administrative Hearings, whereas on the back of the notice of infraction, it states that you can abate before an inspection. And this seems to be unnecessary and certainly unreasonable, and they would not accept the documents. Now, at the same time, got a vacant building thing stuck up on the front door.
Okay, sir, I do appreciate that this is probably no one likes to get fined, except I think we're teetering into a very fact-specific scenario, and DCRA, though, correct me if I'm wrong, Judge Curry, isn't there a separate calendar that deals with DCRA notices of infraction? That actually, even if it was a housing code violation, if the city is going after a landlord for violating the housing code, that would not be adjudicated as part of a tenant petition case. Isn't that a separate docket, if I recall?
So the Office of Administrative Hearings is a central hearing panel. We hear cases from over 40 agencies. And the rental housing cases, tenant petitions, if there is a condition in the tenant petition that is complained of, then that can be talked about in that type of a case. But when they the government is seeking a fine, those are held in different types of cases from rental housing cases. They're different altogether. That's a different jurisdiction. So it's not something that we would talk about in tenant petitions necessarily.
That's why I thought with that. Do we have any other questions for now? Or we can move on to the next.
Could I ask,
Oh, sure.
what all are you planning to cover in this session?
Honestly, this is designed to genuinely be a conversational, informal, hearing from the experts, hearing from the people who are out there every day on this, sharing their experiences, the do's and the don'ts. Pretty much, I guess one of the only things that I guess we wouldn't discuss is a step-by-step how to fill out a tenant petition or how to actually
Well,
present the
can I
case.
ask then, in that case, is it possible for a tenant in court or in a hearing to ask the landlord to be cited for contempt or?
I believe that, Judge Curry, question, I know that as a general rule, administrative law judges don't have what is called equitable power as far as like ordering specific performance of something. If you have if an administrative law judge has a litigant in front of them who is just being absolutely indignant, disrespectful, do OAH ALJs have any contempt powers?
We don't have contempt powers per se. That doesn't mean that there aren't remedies available, but we don't have contempt powers.
Well, what about in landlord tenant case?
Oh,
Could I ask, so contempt in what kind of situation?
Well, for
Yeah.
instance, I know it says in here you don't have to be an attorney to represent someone. If I had a landlord who had a guy who claimed to be an attorney, I'm pretty sure he wasn't, and, I wanted to ask the judge, can you ask for his bar number or whatever, because I think the poor lady was being built by this guy.
oh.
And I hope that doesn't happen too often, but I'm kind of wondering, does this go on?
I mean, that strikes me as something that would be handled with like an unauthorized practice of law investigation through the bar authority. So if that is something, that's what I would suggest. It strikes me that that's where it would be.
In order for a lawyer to sign any pleading, and I think this happens even at the Office of Administrative Hearings, you are supposed to put down your bar number. If you are not licensed in DC, but you are allowed to practice under a certain exception, you have to indicate that. And frankly, if you go to dcbar.org, I believe that anyone can look up if someone is a member in good standing of the bar. Now, that being said, sometimes someone uses a nickname, someone may have gotten married and didn't update their name. So that might not be a slam dunk, but there are ways to verify. I mean, frankly, if a landlord wanted to ask me for my bar number, I would give it. I'd have no hesitation in sharing
Well,
that.
what happened was the judge was telling this guy, well, do you know you can't do this and that? And I felt like saying, Your Honor, you don't even consent because I could tell that she was frustrated. I wondered, were they waiting for me to say something or what?
Were you in housing conditions calendar?
Landlord tenant.
You were in landlord-tenant court, so, all
The
right.
wild, wild west.
Yes. Now, I have
Housing
in a
conditions is
dovetail
worse.
situation. Whoever's running the sound, I feel like I hear like a little ring. Is there a way that we can turn down the volume on the microphone? There's like, I don't know if it's feedback. I'm not a sound person. Just a second, please. All right.
So we're gonna hit on all of these, administrative.
Well, here's the,
complaints, housing conditions.
we don't have a syllabus per se. This is designed to be just an informal
Ask
overall.
questions if we
Yes, you can. Oh yeah, I've been trying to confine them to a theme. Yes, Justin.
I would make just an overall point for all of this though, that
Sure.
Going off of that question, there are many different remedies that just because, let's say you're before landlord-tenant court and you think you can't get one specific remedy, like when you brought up contempt, I started thinking about, well, how can any kind of housing adjudicatory body make a landlord do something? And so, I mean, there are equitable powers that that even like a judge in chambers can exercise if your landlord isn't fixing something. You can go. There's a judge that sits in the housing conditions calendar that is just there in case that there's any kind of like threat to safety.
Health, safety.
And I've used that, and I've seen other attorneys use it successfully to get a court order making your landlord do something. And that's those remedies exist out there. So one thing I would just I would advise any tenant considering their possible courses of action, I would advise just think broadly and think about the whole landscape of potential avenues to bring the claim, because there might be more than one avenue to pursue.
And I think contempt in the context that you're asking about it would be if you receive an order like that and the landlord is not complying. And then you would move to, show cause why they should not be held in contempt. And
That's showing cause is the fancy term for pretty much saying, Judge, please order the person back into your courtroom
Explain
and have them
themselves.
explain why they shouldn't be held in contempt. But I can tell you, I've seen people without lawyers file just a straight up motion for contempt. And judges have a lot of discretion when it comes to contempt. David, you might know this. I believe that in the early years of the Housing Conditions Court, I don't know if there was a pro bono lawyer involved with this, but there was at least one instance where the Housing Conditions judge ordered the landlord into jail for not making repairs. I think that's happened at least one time.
If it's the situation I think you're talking about, I don't think that was Housing Conditions Court. I think that was landlord tenant.
Oh, really?
I don't want to name the landlord though,
No,
so
I
I think I know who you're talking about.
I understand that. Well, because now the other thing is, frequently people will try to bring duplicative cases. I think that when a tenant does it, what'll happen is sometimes they'll file a housing conditions case, but then they're also defending against non-payment of rent. And I've seen at least one instance where the judge in housing conditions issued a dismissal order, and said, if you ever bring another redundant case like this, you will get sanctioned for abuse of the court's time.
And the reason why he's saying that is because, so if you're facing a non-payment of rent case, then in your answer, when you as a tenant are defending against your claims, you would say, well, here's why. Because there's this issue, this issue, this issue, this issue. And that would be, in that instance, the more appropriate.
And theoretically, if you need like urgent relief, you can file a motion for a preliminary injunction or a motion or an application for a temporary restraining order in the landlord-tenant case when you're the defendant. And that's the reason. So it's just a judicial efficiency question. I mean, I think there are unpublished rules in housing conditions court. But one of them, and that the judges actually, the magistrate judges as of now actually follow, is that if a case is filed subsequent, as in after a non-payment of rent case, then it is just automatically dismissed at its initial hearing. But if the housing conditions case is filed before the non-payment of rent case, then the judge does not have to dismiss it. And you could continue to prosecute the housing conditions case next to the landlord-tenant case.
And yes, sir.
Okay, we've all been handed this filing a tenant petition sheet, and just glancing at it, without going into the details of how to file your own, I think there are a lot of danger points here that tenants should be aware of before or if they decide to file a tenant petition. And if you can get to a real court, it's all, sorry, Judge, stay out of OAH. Now, just going down the line very quickly. Type of complaint, check all that apply. God forbid if you don't check the right box or if something doesn't fit your box. And God forbid if you check too many boxes.
Okay.
You're going to get screamed at. Next one, complaint details. Write clearly and briefly. If you don't have your whole Supreme Court brief attached to it, that's your shot. You go into court, the OAH, and they say, well, why didn't you file an addendum with all your, I never. And then one more thing about most cases begin with a mediation section. Never happened. And now let's talk about non-discovery, which you get discovery in any other court in the land. I'll stop there.
Okay, I need to, all right, sir, first of all, here's the thing. It is impossible to put every single solitary what-if fine point on a how-to sheet. That is never designed to be a Now, again, it is patronizing and frankly insulting to say, go talk to an attorney, to presume that everyone has the finance or the time to do that. Unfortunately, if you have specific comments about that form, we are certainly, okay,
about the entire process
we're very interested to hear specific comments about the form. Judge Curry, question. I know this is the case with rental housing. Isn't mediation just a pro forma, isn't it, excuse me, not Latin, isn't it now just a standard practice that the first meeting after a tenant petition is just mediation?
Most times.
Most times.
There are some cases that are not set for, some types of cases that are not set automatically for mediation. That doesn't mean that if the parties are interested in mediating a case that it won't go to mediation, but the majority of tenant petitions, the first thing that happens is it's set for mediation. Now, if one party doesn't show up for some reason, mediation can't happen, and that happens not infrequently.
Fair. And now, in my experience, every time I've had a mediation at OAH, the mediator was an administrative law judge who wasn't currently hearing merits cases in that area, but they were nonetheless familiar with the subject matter. Do you know if those are the only mediators that you use right now, or does OAH ever use outside mediators who aren't judges?
We don't ever use outside mediators, but we do have, our attorney advisors are all certified to mediate as well.
Okay.
So we keep our mediation in-house.
Now, on the note of mediation, this is something that I did want to include in the handout packet, but obviously we couldn't, otherwise the packet would have been very huge. If you go to, Superior Court does have multi-door dispute resolution, and they have something called of a community program, you do not need a live case to do that. Frequently, tenants will say, listen, I don't want to go to court with this. Is there a way that we can just sit down and have someone just hear us out and try to avoid court? The answer is yes, you can do that. And do any of you have experience with that?
Yeah, I've mediated, I believe, 2 cases. I don't want to make a broader statement than I am qualified to give, but every case I've had has been assigned to mediation without, I had the impression that it was mandatory mediation, and I had the impression that it was mandatory mediation before trial, when a jury trial is demanded. I think both on the housing conditions side and in landlord-tenant court. Sorry if I'm wrong about that, but I find it to be very, I find it to be a very smart use of the lawyers and the client's time. Regardless of whether or not you end up resolving the issue at mediation, you sharpen your issues. You figure out, okay, what are the legitimate things that we would want a fact finder to resolve if we can't resolve it here? And frankly, I think, I don't have statistics to back this up, but I would assume that a higher than you would expect percentage of matters that go into mediation are actually resolved there. Both of the matters that I had were resolved there pretty easily. The one practice tip I would give is just be overly prepared, more prepared than you expect to be at mediation. Because if you come in with, your evidentiary rebuttals. So the case that I had, it was a landlord that had accused my client of having a dog in violation of the lease, and the dog was, pardon my French, pooping everywhere. And I met the dog, it was like this big. So like even if it was, it wouldn't be that big of a deal. But in discovery, the landlord had produced pictures of that. It was
the parties couldn't stipulate to fact on that.
Well, actually, it turned out to be a great thing that the landlord did produce these pictures because I showed them to my client. Well, first of all, I mean, it was like the size of my fist, so there's no way that So I brought into mediation a picture of the dog and that picture, and also a picture of my client's floor, which was a tile floor, and it was a wooden floor in the picture. The landlord had produced, and this is a major no-no in legal practice. They produced discovery that was not, it was false. But I mean, having done our homework there, to put that in front of the landlord, and the landlord's attorney knowing immediately, oh well, if this goes forward, I'm gonna have to reproduce the real documents here, and if this other attorney is so inclined, like he could, that's one of those kind of sanctionable issues. So I think being overprepared, treating it as if it is a trial, but a trial that you want to be collegial about, while you also have all of your evidence and kind of have your ammo, but don't shoot. Like just be ready to discuss it amicably.
And you know what? I'd like to dovetail off of that. When you have an attorney, one of the biggest things that comes with having an attorney is the attorney-client privilege. What you tell your lawyer is supposed to stay in confidence. There's a good reason for that. The client is supposed to feel free to share what are their perceived weaknesses. Do not lie to your attorney. That puts all of us in a very awkward position. And, of course, do not lie to a court. And I once read I can't remember what book it was. I think it was it was a legal movie critique book. As lawyers like to say, sometimes somebody has to go to jail. Make sure it's the client. If a client lies to me, I am not lying to the court. I'm not going to lie to the court ever. But anyway, I have a question. Does anyone have the program? What time are we allotted for? I know that we started a little late. 2:45. Okay, so.
We still got a few minutes.
Okay, wonderful.
Remember, we have a raffle too.
Oh, that's right. Thank you. Here. Why don't we do 1, 2, 3? Okay.
I actually have 2 questions for Judge Curry. One is, how long after a hearing, how long do you think it should take to get a final order from OAH?
It depends on how complicated the case is.
Say the most complicated, what would be sort of the maximum amount of
Well, the
time?
most complicated, we had a hearing that involved a tenants association with 20 units, I think, and 14 days of hearings. And the
Wow.
judge managed to get the order out about 6 months later, and that was pretty much working constantly.
Was that the
on trying-
1,000-page opinion?
It
that-
was over, I think it was over 500 pages. And
Okay.
that was 14 days of hearings. That's an incredibly complicated case. Now, in general, our own internal rules suggest that we should issue final orders within 120 days. And if it's a simpler case, it could be shorter. If it's a more complex case, it can
Well,
be
without
longer.
getting into specifics, we have a case that's been at OAH for about 19 years.
Wow. Okay, here's the thing.
And I don't know anything
No,
about that.
here's what I'm going to suggest. Do you have an attorney in this matter?
Yes.
Okay, this is what you may want to. I believe that the rules may allow for just a generic motion to ask for a status update, perhaps, or to just say, "Could you please clarify?" You may want to talk to your attorney about that. So,
I'm sorry, I just had one more question, then I'll turn it over. The other thing, how do you feel about tenants that go in pro se without attorneys? Because another big problem, and I think it's throughout the city, is that tenants who go in with legitimate issues without a lawyer get treated very, very, very shabbily at OAH.
Oh, I'm very sorry to
With
hear
a
that.
lot of disrespect.
And let me say from my own personal experience, as I said earlier, I have dealt with unrepresented parties extensively. And I try to afford as much leeway as possible that I am allowed to do. There's only so much that I can do to help clients or tenants who are unrepresented or to parties who are unrepresented, but I do try to give them as much leeway as possible to present their case in the way that is possible. But I also want to reiterate what I said at the beginning, is that a tenant also needs to help him or herself by reading the rules, especially the instructions that are given, and following those to the best of his or her ability. So, I hope that answers your question.
did you have a question?
Yeah. What happens if you do, I'm just talking about a tenant petition with one apartment, one tenant, one, 2 hours. And if it's been over 2 years and you still haven't gotten an order, what can you do? Because you can only, every 3 years you have to file a new tenant petition. And so I'm on my 4th tenant petition, just waiting for my first tenant petition to get a final order. And it's like, what the hell?
Okay, again, that may be very fact specific. Are you represented by an attorney in that matter that you're talking about now, where you're waiting on the
I
opinion?
had to get an attorney, but.
Okay, because like I said, I do believe that, as with any court, there is a generic rule. There is a rule that says that if you want to request the court to do something, to file a motion, and there may be just a general motion for clarification. I have heard before of something called a motion to expedite the decision. Now,
That's not expeditious. I mean,
but here's
that's
for what
a
it's
training
worth,
that's on.
I don't mean to, this is going to sound very patronizing, so I do apologize. Would you rather have a fast decision that rules against you, or a slower decision that comes out in your favor?
I'd rather not have to file a tenant petition that said,
Okay.
in the estate of.
Oh,
GBD.
oh, oh.
Before you get a judgment, you
I guess. I mean, Judge Curry, do you have anything to add to that? I mean, as a judge, I'm sure taking the time to come here today. Thank you so much. I really appreciate all of that. Like I said, I will pass out my business card if anyone has any follow-up questions. And we also, I believe we have a raffle.
Yeah, before you guys leave, make sure you fill out the evaluation form. That's very important.
Yes.
For us, and what to keep bringing you these types of discussions, we know how you think you're doing, and whether or not you got anything out of it. So I'll collect those before you leave.
Thank you.
Go out the door. In the interim, we have a nice little raffle. So somebody do me the honors. Why don't you do me the honors? I'm gonna shake it up, shake it up, shake it up, okay?
And while you're doing that, I'd like to point out, full disclosure, this is the first time that we have had this panel and that I've done this panel. So please, by all means, even if it's a constructive, I wish we would have addressed this or do X, Y, Z, please share that. We depend on our audience here. All right. Do any of our panelists wish to have anything else? No, again.
All right.
I thank all three of you again for taking the time to join us here today.
Of course.
All right. Who's the lucky winner? Last three digits.
Turn
4,
left, straight and turn left.
8. Oh, 4, 0, 8.
Nice to meet you.
Is that you?
Representing China cases.
All right, you got one more.
That's what I thought, okay.
This is for you?
Oh my gosh.
Congratulations.
That's correct.
Nice to meet you.
Okay.
That's something you needed, right?
Harrison.
Okay,
Thank you so much. I'm sorry that I have more time to spend.
Come on, she's gonna pull it out.
I have to ask you a question. When you were
All right. Last three numbers.
Yeah, because I graduated
4.
before Kingswood became.
Okay, so did my mother.
5.
Yes, no, I'm aware of that. Okay, because now I think it may be the.
Oh, 5. Okay, the lucky winner is in the corner.
Okay.
Yeah,
I wondered
my,
about that.
my parents both went.
Oh, really?
So did my,
My
my
mother.
All right, we got this for you.
my other aunt.
My mother, I'm the oldest of 5.
Here you are.
My fourth sibling is a senior here, so my family's we got a long history with that school.
All right, folks, make sure I get your evaluation form. I'm gonna come around and collect them. Thank you so much.
Reactions? Oh.